All right. Well, good morning. Happy Friday. What is it today? It's already May 5th, halfway through the month of May. Appreciate you being on today's contract class. We're going to dive into the early occupancy and the hidden liabilities behind buyers providing with the keys. Okay. So today we're going to talk about two forms, buyer early occupancy addendum and then the interim occupancy agreement. There's two distinguishes between the two documentations. One, if it's less than 29 days or 30 days or less, and the other one is for more than 29 days, meaning that if the buyer intends to occupy the property prior to closing, okay? Now, it's not a document that I truly like, and most real estate brokers do not like this type of transaction because there's so many different situations and liabilities that can happen, right? One, what if the buyer cannot complete the transaction, right? They don't get the loan. What if they get injured? What if they damage the property, right? And now putting blame that it's not our fault, right? But I also want to give you an understanding in how these documents work if you do intend to go through the initial process, right? So it's an understanding of the BEO and versus the IOA form. Okay, so let's dive right into it and get some knowledge. So, what are we going to cover today? Okay, we're going to cover scenarios, right? A nightmare, real life situations that can happen. The legal shift, what possessions really means. Deep dive into both the documents, the BEO and the IOA forms. And then obviously from a broker standpoint, the risk management, and then we'll open it up with some discussions. All right, so let's open it up with the first scenario, right? The essence of a nightmare, right? It doesn't matter who you represent. If you represent the buyer, if you represent the seller, it doesn't really matter, right? But can I move into a property 3 days before closing because my lease is expiring? I know we're not scheduled to close yet. The property is vacant. Am I allowed to move into the property prior to close of escrow? All right. So this request can create some of the biggest liabilities, okay, in a real estate transaction. Because there's a couple of things that can happen, right? What if the buyer cannot perform and the deal falls apart and escrow ends up canceling? What if the buyer damages the home, right? Many things can happen. What if the buyer then decides to refuse to leave because the deal canceled? Now they want to plop themselves into staying in the property, right? When the seller's intent was to sell the property, right? We didn't want to rent it. We didn't want to have a tenant. We wanted to sell the property with the intent and good faith that the buyer was going to perform, right? And then the deal falls apart, and that can happen. This is why real estate brokers do not recommend to allow a buyer to move into the property prior to close of escrow, because I get those questions all the time. Simon, I have a situation. The buyer is going to be homeless. We're not closing till about a week from now. The property is vacant. The seller and the buyer are okay. I just want to get your advice if we can go with the process of allowing the buyer to move in. Okay, so the question is, how do I feel about it? Well, I see all kinds of red flags, right? And those red flags are indicators that anything can happen, right? And now the property from being vacant is now being occupied, right? So now switches it from a buyer seller to a housing provider and a tenant per se, right? Now, the two distinguishes regarding the two forms of the buyer early occupancy is really for anything less than 30 days. Okay. If you think that the necessary initial process to allow this deal to work and make it a win-win allows the buyer to move in, then you would use this one as a temporary document. If the intent is longer, and there can be many reasons behind the deal not closing, then you pivot into the second form that allows even a longer time frame, which gives you a little bit more protection. There's a lot of language because it's similar to a lease. It's very similar to a lease agreement. It's just a good morning, how you doing? It's just a different language and additional stuff that protects both parties. So I want to give you both of the two different scenarios that you'll get a better understanding. Before we go further, what could go wrong, right? What could go wrong? Who becomes liable? What if escrow never closes? What if the buyer refuses to leave? Who insures coverage if there's an injury? These are four very unique scenarios and questions that you should be able to answer before you handle any type of situation where you're handing the keys to a buyer slash tenant, right? Because the essence is what could really happen, right? If there is a situation that happens prior to close of escrow, the buyer doesn't own the property. The seller still owns the property, right? The buyer is intent to eventually be the homeowner, transfer title, exchange, the title information from the previous seller now to the new buyer. But what happens if it doesn't? What if the deal goes sideways and last minute the lender says we cannot fund this this loan? Something came up and now they decide they cannot perform. That's a big concern too, right? Because now it's uncertain if this buyer can ultimately get the necessary loan to purchase a property. What happens then? And what if the situation is, which is far and few, but what if the buyer after gets so upset and doesn't want to leave and wants to plot themselves there and now necessarily go through the process again to get to get a loan to purchase the property, right? And then lastly, what is the biggest one? Who insures coverage if there's an injury, right? They're having a party, someone slips, someone gets hurt, someone breaks something. Maybe they have a pet bites someone. Who covers the injuries, right? So those are some of the things that I want you to put into perspective and an idea on how you navigate these conversations. So purchase agreement versus possession rights. Okay. Purchase agreement versus possession rights. Before occupancy, right? Buyer equals contract to purchase, right? That's typically you submit an offer, you get your offer accepted, you open escrow, you're going through the due diligence process, right? So the rights flow from the purchase agreement because it's very clear of what the expectations are as a buyer and the seller, right? The common ground is for the deal to successfully close. We all move. We all get the deal closed. Everyone's happy, right? After occupancy, right? Buyer is now considered a potential tenant, right? They're not a buyer. Now you have someone that has been agreed to navigate the position as a tenant instead of as a buyer. Possession creates rights beyond contract rights, exactly as it states, right? Because now there's another layer of responsibilities when it comes to possession prior to close of escrow. The way the courts look at possession, it's really consideration, payments, and the conduct. It's not just necessarily the form that I'll share with you, right? because the form definitely has the black and white. It has all of the ins and outs of what should happen, but sometimes this can go sideways very quick, very fast, like a forest fire. Now, what do we do as real estate professionals, right? So you got to keep that into consideration when you're dealing with a early occupancy situation. The moment possession transfers, there's risk, right? The clear path. If you look at this image, the clear path is clear transaction, right? Close, records, and possession, right? That's typical. I'm the buyer. I submit an offer. Offer gets accepted. I go through my due diligence period, get the appraisal, release contingencies, fund the money. We're waiting for a recording, officially records, and we take possession of the property, right? Congratulations. Here's the keys to your home. That's the way we want all of our deals to go, right? The image on the right now where it says risk path, early occupancy, possession, risk, legal complexity. Yeah, because again, what if those situation doesn't happen or we're not able to get it to the finish line and close the deal? That can happen. So the way the courts evaluate the totality of the situation is based on how it's looked upon, what you have written on these agreements, right? Which is again possession, payments, and conduct, right? The intent for the buyer slash tenant is with every intention to successfully close the deal, even though we're allowing them to stay in possession of the property early, but the intent is for them to eventually get the deal closed, not the other way around. Thinking now that I have the house, I'm not going to get the loan. I'm going to stay here as a tenant now, right? Well, that's not the intent of these two forms. The intent is to allow the flexibility of certain situations. And usually it's when someone is moving from out of state, live back east, they're moving to California, and they already gave possession, and they're asking the property is vacant. Is it okay, to move in so that way it doesn't inconvenience us in a situation? Now, for me, I see it from two different faucets, right? I see the risk that the seller has and also the risk from a buyer, right? And if we can avoid it at all costs, I'm going to say avoid it. Don't do it. Okay. Best situations, best scenarios is for them to move in with family, get a rental, a short term rental, stay at a hotel until the deal closes. If you can avoid this type of situation at all costs, I recommend it. But there is that opportunity for the flexibility as long as both mutually agree, buyer and seller agree to it, then we have the proper documentation that allows that particular situation or scenario to happen. Okay. Now, from a broker's, and I just put that as kind of a funny situation, right? Why brokers lose sleep over early occupancy, right? Now, I don't necessarily lose sleep, but it is a very stressful position because the strain and the pressure from the agent can compromise the situation even worse, right? So, from a point of view as a broker, liability exposure intends beyond the contract. It opens up a lot of situations. The broker may be drawn into a landlord-tenant dispute, right? Well, the intent was to sell the property, not to rent it out, right? So I want you to understand the distinguishes of those. And then documentation gaps become a legal situation as well, right? This is why documenting, putting a lot of emphasis of what the intent is, right? And putting everything in writing will definitely help you if this escalates into something even worse. Early occupancy is not a routine, it's a calculated risk and demands careful management. 100%. Folks, if we're going to go in this direction, allowing the buyer to move into a property before the deal closes, that's already exposure in itself. Not that it's not illegal, because it's legal to do so, and we have the forms to do so, but there's also those risks. And I want to emphasize the importance in how you navigate it. Because again, the intent is always in the right position, right? The buyer needs to move in prior to close. And most transactions successfully close. They close as specified. And now everyone wins, right? But it's those certain situations that it goes sideways very quick, goes left very quick. What do we need to do? How do we navigate those situations? So let's deep dive into buyer early occupancy, which is this form right here. It's a one pager. Okay, that's it. One page. One page. Pretty self-explanatory. Very self-explanatory. Okay, it doesn't really give so much emphasis, but what I do suggest is this little section right here in green that I have, and it's also squared. Okay. That information is one of the most vital statements, in my opinion, regarding the early occupancy addendum. And it says, brokers. Brokers do not recommend early occupancy. Broker has advised buyer and seller to consult with a qualified California real estate attorney to determine whether entering into such an addendum temporarily or permanently changes the nature of their status as a buyer and a seller, and now the legal consequences and implications of an early occupancy. If buyer and seller agree to early occupancy, they're doing it against the advice of the broker at their own risk. Okay, that's our disclaimer. That's our protection. We're telling you, we don't recommend it because it adds more chaos to the transaction that we just do not need. So that's our protection that says to the buyer and the sellers, hey, you guys want to do this? That's on you. But if this goes sideways, you cannot blame the brokerage, the agents involved, because we advised you this is a big risk and we don't recommend it. But if you guys want to do it, okay, well, there's documentation that you must sign to be in agreement. Does that make sense? Okay. So what the form actually says, okay, it's occupancy terms, consideration, maintenance, insurance, and warnings, okay? And that's what it is. It talks about terms, it talks about consideration, it talks about utilities, it talks about entry, it talks about maintenance and alterations, it talks about assignments and subleading, it talks about insurance, it also talks about waivers, and you can add additional terms to this or supplements. Both buyer and seller sign this agreement, and then that allows the buyer early occupancy prior to close of escrow. Okay. In this form, it says on the very top, for buyer pre-closing possession of 29 or fewer days. Buyer pre-closing occupancy of 30 or more days, then you must use the interim occupancy agreement CAR form IOA. Note, local rent control or other law regarding tenant rights may impact buyer and seller's right and obligations. It is considered a tenant housing providing agreement, right? Even though, Simon, wait a minute, it's a buyer, it's a seller, they're just allowing early possession of the property. I get it. But here's the problem. If this goes sideways, now what is the seller's position to ultimately push them out, cancel this agreement, having them move out of the property, right? Because the intent of the seller is to sell the property. So I want to be clear on that. So occupancy in terms and dates, right? Exact start and end dates, right? It's very clear of what this form allows the buyer and the seller to do. But it must be specified. Termination triggers include fail of escrow mutual agreement of default, right? So it really gives a defined situation. And I want to read this because I think it's very important. Term. The buyer is granted possession of the property beginning on so-and-so calendar day before close of escrow. The buyer early occupancy addendum shall be terminated on the close of escrow in the agreement. Buyer has no right to remain in possession beyond the terms unless escrow has been extended by a mutual agreement, sequential agreement for possession agreed in a separate written agreement and signed by the buyer and the seller. Prior to the end of such terms, buyer may be responsible for court awarded damages. The buyer remains beyond the termination without a sequential written agreement. Okay. So it clearly states that the intent of this agreement is solely to allow the opportunity to get the deal closed. This is not, again, a tenant housing provider lease agreement month to month. If that was the case, this is not the transaction. This is, again, for a buyer that's moving in with the intent that they're going to close the deal because they're purchasing the property. An extension issue arises, right? Closing and delay, the agreement may not automatically extend. So here becomes a major liability, right? You have to make sure that you're documenting. If the deal was scheduled to close in 7 days and it doesn't close, you need to do an extension of time, allowing both buyer and seller to come to an agreement that if we have to give an extension, you have to put in a time because, again, this changes the trajectory of this form and everyone has to be in alignment. Everyone has to be in agreement before. And if there's not an agreement, then that's it. The deal doesn't happen. The buyer will unfortunately have to vacate the property. It executes the termination agreement. Okay, so vague dates create vague rights. Precise language protects all parties, right? The more you can put into the understanding of both parties, the better likelihood that if this goes sideways, there is consideration of how to navigate the agreements in the process. What the buyer pays. Okay, so that's part of the consideration. Buyer pays early occupancy fee. Option includes can be a flat fee, daily rate, or deposit increase. Why should a buyer occupancy a seller property for free, right? So the essence is it really depends. You can do it as good gesture, because ultimately I'm the seller, the property is eventually going to sell. I'm going to get my proceeds. We're done, right? So there's an ability to go in with the intent of consideration of income or no income generated, right? That's a discretion between both parties. Okay. Most sellers will allow it depending on how much time, right? If it's 2 or 3 days, maybe they'll say, yeah, at no cost. But if it's more than 3 days, 5 days, 7 days, 14 days, that's a lot of time with the understanding that there may be a risk of this deal not closing. And I'll share a story with you because this exactly happened to an agent of ours. The um, the agent represented the seller. They were having challenges with the loan. The buyer and seller agreed to early occupancy. Then the lender said, we cannot qualify the buyer. It's going to take about 6 months to cure some discrepancies in their credit, and it's going to take about 6 months. Well, thank goodness that the seller was okay with it. But obviously now it changes because there's still a mortgage payment that needs to be paid, right? So both the buyer and the seller came to an agreement. And eventually, yeah, I think it was about seven months after the deal ultimately canceled. The buyer had moved in early with the understanding that they were going to get the property and close it. That did not happen. But 7 months later, they were able to get a new loan going. Their FICO scores increased, and they were able to obtain the deal. And the buyer ended up closing, and the seller ended up selling the property and getting their proceeds. But it's still a very risky situation. Utilities, buyer assumes responsibility for utilities, right? Common practice, right? You're going to move in, you're going to be responsible for the utilities, right? The water, the trash, the electricity, cable, internet, and all that fun stuff, right? Who is responsible for all that, right? Well, the person that's taking possession, that's the one that's going to take responsibility. I don't know your behaviors. You leave the lights 24/7. Am I going to be, as an owner, responsible for that? No. You still got to consider it as a tenant slash housing provider agreement, even though it's still a buyer seller transaction. Consideration is not optional. It defines the relationship, right? Put it all in writing so there is no misunderstanding and no one can say, well, that's not what I thought this agreement was, right? Crystal clear. So the form also talks about insurance, right? The insurance gap, a critical part of the warning situation, right? The seller's homeowner's policy, okay? And here's the situation. This is why it's vital and very important because if I'm a homeowner, I'm selling my property. This is my primary home, right? And now I have to go through this situation of allowing the buyer, which again, I wouldn't recommend it. I would say, look, if we can't make it work, then we might as well just cancel. Okay. I'm not going to take the risk of you guys moving into the property without really getting the insurance because right now a lot of lenders are having a hard time trying to get these buyers qualified, right? So I wouldn't recommend it. But in those instances, if the seller does allow it, right, and this is their primary home, well, the problem here is their policy may not have coverage that causes by a non-insured occupant, right? Because an insurance of a property, well, they will ask you, is this an investment or is this owner occupancy, right? Owner occupant. The insurance premium changes from a owner occupant to a rental. As a rental, it's a lot higher, right? And what if you allow this? Don't think, oh my gosh, I never updated my homeowner's insurance, right, for the time being, and you leave it alone. Now the buyer slash tenant damages the property. There's a fire, and the house catches on fire, right? And the insurance finds out you are not occupying the property. They find out that there was another person living in the property. They may deny your insurance claim. So it's vital and important before you advise your clients to go this direction. I would say reach out to your insurance carrier, throw a scenario, and ask if they have an insurance gap that allows for a temporary tenant type of situation, right? Because again, the insurance doesn't know. The insurance knows that you are the homeowner, you're living in the property. They will insure you. And I know for a fact that these policies has very specific because their goal is not to pay out on something that was out of the agreement, right? And if you do not allow or let the insurance that there is another party living in the property temporarily, and something happens within that time frame, they may decline your insurance. And if the house is significantly damaged and it's hundreds of thousands of dollars, that's a problem, right? So you need to educate your clients. Look, before you decide to make this decision, I would encourage you speak with your homeowner's insurance, give them the scenario that you're in escrow, the buyer is planning to close the deal. They're basically homeless. We're allowing them to live. Is there some type of premium that I can pay, like a rentals coverage, right? For a 30-day policy, right? On top of your insurance, there may be a supplement for that 30-day time frame that the buyer slash tenant is staying in there. And if anything happens, you're covered. Does that make sense? Yeah. Okay. Buyer's personal property insurance does not automatically cover the physical structure or liability within a property not yet owned, right? Absolutely, right? Because again, they're not owners of the properties of the property. They're basically just a tenant occupying the property. So if the buyer, again, as this little image here, buyer floods the kitchen while moving, who's responsible for that? Okay. Well, it's the owner. The seller is responsible for it because the buyer can says, yeah, you know what? There was a leak. We didn't know. We came back and we can swim in your house, right? They're not going to take blame for it, right? This is why it's crucial and important that you know and understand if you're doing any type of early occupancy, you got to treat it and make sure you have the proper insurance to cover you for that time frame. Maintenance and assignment in the warning box. Okay, so buyers responsible for upkeeping and the minor maintenance during occupancies. Again, it's pretty self-explanatory. It talks about, what the responsibilities are. Buyers shall maintain the property, including the pool, spa, landscaping, grounds, and all seller's personal property, including the sale in a sequential same condition. As the date of this form, except it provided in this agreement, buyers shall not make any alterations to the property without first obtaining seller's prior written consent. Okay. So if the buyer plans to do, some stuff such as, oh, we're going to own this property. We want to start doing landscaping here, right? And you start doing all that, do not do it until you get the written consent from the seller. You don't own the property. You may think that in the next 7 to 14 days, it's going to be your property, but anything can happen, right? So you don't want to guide your clients if they ask you, hey, can we start doing some modifications? Can we paint the house? That could be a problem. What if you don't get the loan and you just spend thousands of dollars painting the interior and exterior of the home, thinking this is our home, we want to make it beautiful? And that's happened in the past where people start ripping floors, knocking down walls, and they don't even own the property. They believe they own because they're in there. What happens if they don't get the loan? That's a significant issue or problem, right? And now who has the burden of curing something, right? Well, the seller would be. And if there was damage, then the seller would have to go after the buyer for damage. So this is why it's clearly written in this agreement that no type of alterations shall be done without without the seller's consent. The form explicit, and it goes into the warning, which I said earlier. This is where this comes. And when car includes a warning box large enough that demands your full attention on it. So part of the risk here are 7 ways that this situation could go wrong, right? Which we've already explained. 1, escrow falls, right? The escrow doesn't happen, right? 2, damage before close, right? We talked about, damages that the buyer may have done, right? I've seen a situation many years ago. They let their teenage kid move the car from the driveway into the garage. You know where this is going, okay? And apparently, when the teenager put the vehicle in drive, they accelerated too quick and went in the garage and went in, hit the washer and dryer because the washer and dryer was right in front, blew the wall that led to the family room. So half of the car was in the garage, half of the car was in the living room. Yeah. So those were damages right there. Insurance, we talked about insurance too, the importance of making sure that if they're going in this direction, that they check with their insurance carrier and what difference in premium they may have to pay. Peace of mind, folks, because you can take the gamble, right? But what happens if during that time there's issues with the property and now you're stuck with the big bill? Or buyer refuses to leave, right? They're so upset, and they want to take it on us. That could be a problem if they decide to not leave because the contract says this terminates if you don't get the deal closed. This agreement terminates. Well, that's not what we have. We have a written agreement, and we're staying here. And the seller needs to sell the property because they're leaving out of state, and this was the proceeds they needed to put a substantial down payment on their new home out in Florida, as an example, right? That can be a problem. Utilities, all right, that might be a dispute, and make sure that they transfer all that. And remember, also that triggers, in my opinion, with the insurance carrier. I don't know that may flag when they change of utilities, right? From the homeowners, water, trash, electricity, cable, and now there's a change in the utilities, right? That may ultimately flag the insurance carrier, and then you get a letter. I have some friends in Manhattan Beach who apparently did not say anything to the insurance carrier, and they flagged it. And because they flagged it, they wanted to cancel the insurance. It's like, wait a minute. Yeah, you didn't tell us that you were renting the place. So it's vital and important to understand your position. A big one, injury, liability, right? I remember many years ago there was an incident, not on this type of situation, but it was an incident where an agent was showing a property that had a two-story. And actually, it was a tri-level, stairs to the upstairs and then stairs down to the garage. And the lighting was really, really bad that one of the potential buyers slipped. There was no rail, slipped, and ultimately became paralyzed from the neck down. Yeah. Yeah, the buyer ultimately ended up suing the homeowner for improper lighting, no rails. I mean, and they didn't even own the property. They were just showing the property. But because it happened, he got paralyzed. So if I remember, there was a lot of money that ultimately they went after I think in the seven figures. Because the guy had a good job, and unfortunately, because he was paralyzed from the neck down, that was it. Couldn't continue. Neck down. Yeah, he was paralyzed because he slipped and he went down the stairs, and he immediately knew, hey, I can't feel any of my functions. Paramedics came. The report was done. I need to follow up with the agent. As a matter of fact, I spoke with her yesterday on something else. She's no longer with the company, but she was representing the buyers. That was her clients. So thank goodness we were not involved on that litigation and lawsuit. It took years, but I don't remember. I believe so. Yeah, yeah. They ended up paying a big chunk of it. So. Again, injuries can happen at any time, right? I know there was another situation where an agent went inside a garage. This guy was 7 feet. The agent was like 7 feet. The beam was low. He claims that he banged himself in the head and ultimately put a claim against the company, against the agents. And it was co-listing, so there was two brokerages involved. So he went after both of the brokerages. We had, thank goodness, we had a waiver that said, we don't take responsibility, and the seller signed and agreed that he would take responsibility. So that company and the seller ultimately settled with the buyer. The guy wanted like $350,000. I think they ended up settling for 25,000. So just be mindful, and it's not about the number. It's really the strain of dealing with something when you can be focusing on your business, right? So just be mindful about that. All right. The scenario that changes everything. Buyer moves furniture in, escrow is delayed. Buyer says, I am staying. Now what? What legal tools do you have, and why didn't the BEO protect you here, right? So again, I want you to be mindful about this, because the intent of this form is really just for temporary occupancy until the deal closes. That's really what it is. And if the deal does not close, it doesn't give the buyer the right to stay in the property. And we need to set those expectations from the very beginning, that this is not a month-to-month or a lease. This is a license to stay there until we get the deal done. And it's a convenience for everyone, because we're trying to push to get to the finish line, right? So you got to be mindful that if you do have a situation that escalates, that they're firm and they're not leaving, then attorneys need to be involved. We as real estate agents just back out of this and let the seller speak with their legal counsel and guide them on what next process, right? Typically, it may be a eviction process. Well, wait a minute, it's a license to stay, not a month-to-month or lease. Well, we live in the state of California, and unfortunately, there's a lot of tenant rights. It's very sad, but it's so true. All right, let's talk about now the second form, which the second form really, it's 8 pages. It's like a lease. It's like a lease, and there's 8 pages. This is more of a lease agreement, but it's still an interim occupancy agreement. This is no different than the early occupancy, but this is for more than 29 days staying in the property. Okay. And does it happen? Yeah, it happens. So if that's the case and scenario, you're going to utilize this form, the IOA form, when occupancy becomes tenancy per se, right? So there's 8 pages to this agreement. It talks about rent, deposits, late fees, utilities, parking, pets, mediation, and so forth. So the core financial provision here. So it talks about rent provisions, monthly rent amounts, security deposits. Again, you treat this similar to a month-to-month or a lease agreement, but it also emphasizes that this is an interim occupancy. It's not full or permanent, right? So they don't think, well, if we got the property, we're enjoying the property, there's no need for us to purchase this anymore, right? We're just going to stay here. It's a lot cheaper anyways to rent than it is to get a mortgage. And that might be the mindset of a buyer, right? So it's still considered a temporary license. Okay. Oops. Sorry about this. All right. So people on Zoom, do you still see the presentation? I'm sorry.
Yes.
Okay, thanks. All right, so utilities and parking and pets and smoking. Utilities, right? Who is responsible? The buyer tenant responsible for all services. Seller protects from post occupancy. Pets permission. It depends on the breed restrictions. So there's language on this form. If it's a condominium, right? A condominium or some type of parking structure, where it's not your typical garage, but it's more like, hey, I got one slot, two slots, or three slots. You want to emphasize the importance of what their obligations are. Again, part of the language here is about smoking, right? Prohibited inside the property because that's could cause a fire. All right. It also talks about the maintenance and rules and legal disclosures, right? Maintenance, rules, and mediation, right? If there is a dispute, no difference than the purchase agreement. There is language there that talks about if we cannot come to a resolution, we must go through a mediation process, right? And ultimately, with the mediator's responsibility, it's not to side for one or the other, it's to come to an agreement. That's really what a mediator does is, hey, are you planning to buy this or you're not planning to buy? You need to vacate the property or you need to do this or you need to do that. But there's language on this agreement. Agency disclosure, again, just for the importance of transparency, right? The statutory disclosure requirements apply. Agents must still disclose their representation, even though this is considered a interim occupancy, which is a temporary license granted to allow the buyer to move in prior to close of escrow. But this is now for more than 29 days. So the differences between the two forms, right? Which one is just a singular form where the IOA is 8 pages long, right? So it's more like a lease agreement. So the BEO is the short occupancy. It's simpler structure, limited terms. It's more focus on purchase focus. It does have a little bit more of a high ambiguity on this form because it's a temporary license to stay, but it also gives more of a greater concern because it doesn't have really additional protection if this goes sideways and the buyer decides to not vacate the property, right? Where the interim occupancy agreement has a longer occupancy, as we stated, it's more tented structure. It has intensive rights that protect both parties, and it is more of a occupancy focus instead of a purchase focus, right? This may be where we have to stop because the buyer cannot qualify, and we may have to revisit, 5, 3, or 6 months from now, right? Because there's an issue. Maybe something came up on their credit, right? That now they have to take care of it, and it's not going to happen overnight, right? So as long as the buyer and the seller are in agreement, then this is the direction that they can go. There is more protection, and it's better for risk management as well. Choosing the right form is practical. Look, at the end, always seek broker advice or leadership advice, right? To be able to navigate what form you must use if the buyer plans to occupy the property prior to closing, right? So no agreement needed. Obviously, if the deal closes, it's a 30-day escrow. We're all happy. Everyone wins. And you move on, right? Let me just let these people in real quick. Okay, so buyer requests early occupancy, right? And it can be that situation. They're moving from back east. The house is vacant. They have a lot of furniture coming in. We're asking for 2 days to move in before we close the deal, right? It may be the weekend, and it's like it works, and we're scheduled to close on Tuesday. You see where I'm going with this. It just makes sense. Look, you want to make the buyer happy. They're going to close. They've released all contingencies. They already did loan docs. Everything is solid. Then I can see this direction as a convenience instead of inconvenience the buyer to go place their stuff in a storage, go move into a hotel or a family. It just makes it a whole lot more seamless to just let them move into the property, right? So that's where the form comes into play, right? Occupancy 3 days or fewer with clear close date, right? We know that it's going to close. We're just conveniently helping the buyer move in their stuff. They're going to be the owners in a few days, right? Or even a few weeks, right? Because this form allows you that time frame. Um, use with caution and full documentation, right? So make sure that it's clearly concise and everyone's on the same page when it comes to that. Then the IOA, treat it as a tenancy structure. Again, those are for that long term. Again, either form, I don't recommend it. If you can avoid them moving into the property, even better. Even better. Okay. So, questions here. So, one, escrow delays 14 days after move in, what governs, right? So let's kind of dive deep into this situation, right? Everything is going good, no problems. And now we have a delay. Something happens with the loan. The lender reaches out to you. You're the listing agent, say, Houston, we have a problem. We're going to need to extend the time frame. And now, all of this is new news to the buyer. All of this is new news to the seller, and they already have a moving company coming in this Friday, right? Or next Tuesday, as an example. They don't want to delay this. The house is vacant. What do we do here, right? Well, that's where you think outside the box. Not that you want to encourage it, but it's part of the option. Say, hey, you know what? Because the seller can say no to it. You may bring it up because you're trying to take care of your buyer's best interest. They already have a moving truck thinking they were going to close, and now the lender says, we have a problem. We need an additional 2 more weeks to close. That can happen. But we have the trucking company coming in on Tuesday to move and start putting everything into their new home, right? So then that's when you need to negotiate, work with the listing agent to come to an agreement, right? Number two, buyer child damages the hardwood floors. Who pays? Okay. So you allow the buyer to move in early occupancy, and then you happen to go in there, or the buyer says, hey, there's damage to this floor. Who would be responsible for that? Right. Okay. What if the buyer says, we didn't do that? The owner, but we're going to close this deal in a week from today. We already negotiated terms. I'm not going to pay for the floor. That's your responsibility, right?
To kind of nitpick on things instead of just already being there, kind of just accepting what they have and kind of just fix, like, working with it, right?
Yeah. I mean, these are just very unique situations that can happen, right? I mean, technically, if a buyer is going to be moving in earlier before it closes, stuff like this should have been addressed if there was damage, right? Because the buyer has their due diligence to do a thorough inspections to the property. Now, the case here is, what if the buyer's child damages the floor, really damages the floor, and you find out, that is a problem because there's still uncertainty that the buyer can close. What happens? The damage is so severe that they need to replace the whole floor, and that's $8,000. And now the buyer decides they want to cancel. Think about that situation, right? I'm just throwing out curveballs here, folks. Okay, that's all I'm doing. You got to know how to maneuver, how to navigate those, right? Well, in that case, if we can prove that the buyer did this, then yeah, we can go after the buyer for damages, right? Now, if the deal closes, then we're good. You're responsible. That's on you. It's one of those unique situations where the deal doesn't go through, the buyer cannot perform, and ultimately decides to cancel. There is the issue, right? This is why you want to make sure that these documents are signed. Don't just take face value. Yeah, move in, have the proper documentation in place. Buyer gets injured on the property, who is liable, right? Well, you're still the owner of the property, right? So technically speaking, the owner is responsible for anything that happens to anyone that you're having occupy the property, right? What if the mailman is delivering mail and bites, excuse me, I take it back in reverse. The buyer slash tenant has a dog and bites the mailman, right? When delivering mail, and then that mail carrier wants to sue, right? Well, they're going to sue the property owner, not really the individual that had the dog, right? because they're going to look at the address, they're going to see who's on title, who's responsible for all this stuff too. So this is why you want to have additional coverage and protect yourself, right? Because the insurance carrier may deny, and what if they're asking for $50,000 in damages? I can't work anymore because I got bid. I have all of these medical expenses, attorney fees, and all that, right? It happens. Okay, it happens. That happened to me. Okay, I was visiting my parents early 2000. My dog, she was a pit bull boxer, cute, beautiful dog. She was a pup. She was probably a year, 2 years, and yeah, well, I mean, yeah, but I was a homeowner, so I had the insurance coverage, but I ended up taking the dog to my parents to go visit them, and I let the dog roam in the front. Well, the mailbox at that time was closer to the entrance to the door. The mail carrier saw the dog and still alerted to go in and wanted to pet the dog. My sister, because I wasn't there at the time, I had went to the market or something to go pick up some stuff. My sister says, yeah, the mail carrier went out to pet the dog, and the dog ended up biting her on the ankle. Well, she ended up suing, and she didn't sue me. She sued my parents because my parents were the owners of the property. And my mom's like, what the heck? I go, Mom, I'm so sorry. you know, um, the good thing is, when I came back, my sister says, oh my God, Punchy, her name was Punchy. Punchy bit the mail carrier. I go, what happened? She goes, I don't know. She freaked out. So I says, okay, well, let me go see if she was still in the area. So I flag her. I says, hi. We were the owners of the property that I believe there was an incident where our dogs bit you. And she goes, yeah, the dog attacked me. So she went. I says, can I see where the dog? I took a picture. Thank goodness it was a surface scratch, literally a surface scratch. It wasn't no teeth marks, nothing penetrate, because I got bit by a pit bull when I was a kid, and I have scars to prove it. Literally, scars to prove it. This was a scratch. Well, at the time, I still didn't know she was going to sue, but like 2, 3 weeks later, we get a letter from an attorney's office that we represent the mail carrier. So we unfortunately had to call the insurance carrier. Thank goodness. Thank goodness that the insurance took care of it, because my parents didn't have a dog. That was my dog. They didn't have to pay out. We ended up paying, I think, like $12,000-$15,000 of damages. But the good thing, the insurance took care of it. But as soon as they took care of it, they also terminated the insurance with my parents, so we had to find another insurance carrier as well. Okay, it's just one of those situations. You just never know. Exactly. Never know. Right. Seller changes mind after occupancy. What happens, right? It just can happen. Loan is denied after buyer has already moved in, right? That can happen, and it's happened in the past. Buyer refuses to vacate after fail escrow. What the seller's remedy, right? So I want you to just keep this in mind. If that situation happens to go left field, it's going to go quick left field, right? You got to just know how to maneuver and navigate that transaction. We're always hoping for the best. All right, buyer takes possession under the BEO, keys, transfer furniture, moves in. This is, again, early occupancy. 14 days in, lender denies the loan as cannot close. Purchase agreement terminates. Buyer refuses to vacate. Seller has no, that's a misspell. Seller remedy depends on whether the landlord-tenant relationships was created. And that's, again, why it's important to have these agreements, because if we have to go into a lawsuit, here's our proof, here's our receipt that this was a temporary, not a long-term tenancy. Again, here's another scenario. Buyer injures during early occupancy, right? Seller's liability shall be considered the owner and potential liable for the premises conditions, right? Because they're going to say, well, yeah, I slipped, but it's because the floor is uneven, and I'm suing. I'm suing the owner. That can happen. Well, wait a minute. You're buying the property and you're suing. We just live in a state that allows these crazy type of situations and lawsuits. Buyer assumes risk, right? So this is why, again, these forms allow the understanding and the importance. We want all these transactions to go as smooth as possible, but they can go sideways very, very fast. Injure claims do not pause because the deal was almost closed, right? Mm-hmm. Someone is still responsible for it, and just be mindful and know and understand that this is why we don't recommend this to happen, because they are not the actual owners. Wait, get the deal closed. That's your best safe bet. It's like, as much as we love to, unfortunately, we're not going to be able to allow this, until the deal is officially recorded, and then you're the owner of the property. You can do whatever you want. Move in. Okay, that's my best recommendation for this type of situation. Don't do it. Just don't do it. How brokers protect themselves in the documentation standards, right? Use the correct form for the type of situation. Remember the singular form or the interim occupancy agreement. Document everything, right? Dates, considerations, utility transfers, advise clients in writing, provide written cautions about risk, which a lot of this forms already, so you don't have to think, just have them sign these agreement. And obviously consult with legal counsel when occupancy extends or escrow stalls, right? You direct them back to their attorneys to get legal advice. And then last is access before closing is never just a convenience, right? The day someone gets keys before recording, risk changes dramatically. Slow down, document carefully, and remember, solving convenience problems should never create a legal problem. Use the right forms, document every step, protect your clients and yourselves. And with that, that concludes our class. All right. A lot of information. Okay. So let's see. No chats today. Wow. Surprisingly, no one has. Okay. Thank you. I appreciate it. All right. Well, let me go ahead and pause the recording.